Mr. Epstein, how long have you been sexually attracted to underage minor females?
Objection, harassing, argumentative. Are you kidding?
Now, convicted sex offender Jeffrey Epstein was no stranger to depositions. The accused trafficker was questioned on the record in relation to civil lawsuits that were filed against him by women who claimed they were just teenagers when they were pulled into Epstein's alleged despicable web. Well, we found one of those depositions in the Epstein files release, and it gives you an idea of how Epstein himself, his own attorneys, and opposing counsel approached these cases. And let me tell you, it is very illuminating.
The files are thick, the transcripts are dense, the testimony has been delivered, convictions have been secured, and yet, a lingering question refuses to disappear. What's still missing? The case surrounding Jeffrey Epstein and the testimony that helped convict Ghislaine Maxwell was expected to close the chapter on one of the most explosive scandals in modern history. Instead, it left an uneasy silence, the kind that makes
coverage of the Epstein files release. We have gone through thousands and thousands of documents, photos, videos, and I will tell you, it's pretty much like we've barely scratched the surface when you think about millions and millions of pages. But we are learning new details, and we are getting the chance to view more evidence against Jeffrey Epstein every day, or at least more what was going on in his life. Now, in a previous sidebar, we looked at some of the creepiest, cringiest videos of Epstein. For example, this selfie video of him making weird and unsettling faces into the camera. You have another showing him standing up on a countertop in a large kitchen, then getting down and literally chasing a female around the room. There's also footage of him dancing with someone in what appears to be a hallway. But I will tell you, also in these files, released under the Epstein Files Transparency Act, are depositions related to civil lawsuits that were filed against Epstein and his on-again, off-again associate, girlfriend, alleged madam Ghislaine Maxwell, who, by the way, was convicted and sentenced to 20 years in prison on sex trafficking charges. Now, what I want to do today is I want to dig into one of those video depositions that was taken in February of 2010. This is part of a lawsuit that was filed against Epstein by an alleged victim. She's referred to as LM. She sued Epstein in Palm Beach County, Florida District Court, claiming that essentially she was lured to his home and forced to perform sex acts, eventually becoming what she would call a sex slave. Now, Epstein actually went on the offensive. He would actually end up suing the lawyers in this case, claiming basically that they had tricked people into filing civil claims against him, thus defrauding him and making Epstein look bad. Court paperwork called it a Ponzi scheme, and his disdain for this law firm will come up several times in his responses. You're going to see it. But I do want to play you some really interesting clips from the deposition, because the camera focuses on Epstein, but off camera, you're going to hear from LM's attorney, Brad Edwards, and Epstein's attorney, Michael Pike, okay? Now, Brad Edwards had worked for a law firm called Rothstein, Rosenfeld, and Adler. Apparently, the top partners at that law firm would eventually be charged and later convicted of financial crimes. We're talking things like racketeering conspiracy, wire fraud, money laundering. And Edwards points out at times during the deposition, essentially, look, I'm there representing LM. The accusations against this former firm are irrelevant and essentially a distraction that Epstein's making. Now, to set the timeline for you, because I think that's important, this deposition, again, is in 2010. This is after Epstein has already been convicted. Remember, he pled guilty to those Florida state sex crimes charges, solicitation of prostitution with a minor. He spent some time in jail as part of that sweetheart deal. He was able to avoid federal charges. So now he's facing this civil litigation. And you can tell immediately, Edwards is not going to get much out of Epstein.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you give us your name?
Jeffrey Epstein.
Mr. Epstein, you made a comment when you came in the room that you were appreciative of me being respectful to your housekeeper yesterday, and I intend for that to be the same with you today. I want to start by asking you, at this point, we've gone through a lot of discovery in this case. There aren't many disputed facts as to what actually happened at your house. And generally, I think you would agree that you devised a way for young females to come to your house and engage in varying degrees of sexual activity. Some of the girls as young as 12, some of them as old as 17 or so, most in between. But as of yet, you haven't provided an explanation. So I want to provide.
People wonder whether the final page has truly been turned. Because when the spotlight fades and the courtroom empties, what remains are gaps. The files we've seen, and the ones we haven't. Over the years, thousands of pages have been unsealed: depositions, flight manifests, interview summaries, financial records. Each release generated headlines. Each batch of documents promised clarity. But many pages remain redacted. Some filings are still sealed. Certain names are obscured. Certain locations blacked out. Certain details withheld under legal protections. Redactions are not unusual in cases involving minors or sensitive testimony. But in a case this vast, this powerful, every black bar across a page fuels suspicion. What is being protected? Who is being protected? And why? The presence of withheld information creates a vacuum, and vacuums invite speculation. Testimony that opened doors, but not all of them. Maxwell's trial provided disturbing and detailed testimony. Survivors described recruitment tactics. They described manipulation, grooming, and a system designed to operate quietly.
Have told me that I can't, and I must invoke my 5th, 6th, and 14th Amendment rights, or I risk losing their counsel. Accordingly, I therefore assert those rights. Sorry.
And in addition to that, I'm going to move to strike counsel's statement as narrative as well.
I understand. We wanted to provide him the opportunity if today was going to be the day.
Same thing, move to strike narrative.
Mr. Epstein, how long have you been sexually attracted to underage minor females?
Objection, harassing, argumentative.
Are you kidding?
No, I mean, I don't feel like I'm divulging any secrets here, right?
Move to strike.
No, that's the question.
I'd like to answer that question as well. I'll get all your other questions today. However, I have to follow my attorney's advice. They have told me that I must invoke my 5th, 6th, and 14th Amendment right to not answer those questions today, or any questions relevant to this lawsuit. So accordingly, I'm going to assert those rights, and under the Constitution is guaranteed by the 5th, 6th, and 14th Amendment.
Okay. Would you consider yourself addicted to sex with minor females?
Same objections.
You know, Mr. Edwards, I want to be very respectful. And as the current U.S. Attorney has described your law firm as a criminal enterprise and part of one of the largest frauds in Florida's history, it's been reported that your firm has fabricated multiple cases against me in order to fleece unsuspecting investors out of millions and millions of dollars. So unfortunately, at this time, though I'd like to answer that question, on advice of counsel, I'm going to have to refrain and assert my 5th, 6th, and 14th Amendment right.
Can you then provide an explanation for what relevance that soliloquy of yours has to whether or not you engaged in sex acts with she was a minor?
Objection. No, he cannot. Argumentative, compound, harassing.
Mr. Pike, with all due respect, it wasn't my idea for him to give this speech about a former RRA law firm. I'm just asking him, elaborate on that.
Counsel, I'm working with your follow-up question. So I'm objecting, and I'm objecting to form, and stating the reasons on the record as to why the form is required to be objected to based upon your question.
Will he elaborate on the relevance of that soliloquy to his touching when she was 13, 14, and 15 years old in a sexual manner?
I'm going to object again, argumentative, compound, harassing, and irrelevant as worded.
You can answer.
I'd like to answer. However, I'm going to have to assert my 5th Amendment, 6th Amendment, and 14th Amendment right, as advised by my counsel. Otherwise, I risk losing their advice.
Mr. Epstein, have you ever been diagnosed with a sex addiction to minors by a psychologist or other medical professional?
I intend to respond to all your questions at some relevant time. However, today, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must
behind wealth and status. The jury heard about how access was gained, how trust was earned, how exploitation was hidden in plain sight. The verdict delivered accountability for specific crimes. But trials are narrow by design. They focus on defined charges. They establish elements required for conviction. They are not sweeping exposés of every person who ever crossed paths with the accused. So when the testimony ended, many felt something unresolved. The courtroom answered some questions, but not all. The missing trial. Perhaps the largest void is the trial that never happened. The financier died while awaiting federal prosecution. Official rulings declared it a suicide. Security failures were documented. Investigations were conducted. Yet without a public trial, there was no full evidentiary airing, no cross-examinations, no complete presentation of the government's case, no public confrontation of every alleged connection. A trial would have forced testimony under oath from witnesses across the network. It would have introduced evidence in open court. It would have answered some questions.
Any questions relevant to this lawsuit, and I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, I assert my Fifth, Sixth, and 14th Amendment rights to the United States Constitution.
In addition to that, Mr. Edwards, as the court has ruled in several matters, Mr. Epstein's medical history is not relevant at this time, nor has he placed same at issue in this case.
Understood. Mr. Epstein, were you sexually abused as a minor?
Right. Again?
Were you sexually abused as a minor?
You know, I'd like to respond to all your, if any, questions seem to be relevant, but I would like to respond to any relevant question at this time. However, my attorneys have counseled me that I cannot provide answers to the questions relevant to this lawsuit today. I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, then, I assert my Fifth, Sixth, and 14th Amendment right to the United States Constitution.
Isn't it true that you have engaged in some sexual interaction with hundreds of underage minor females in the last 10 years of your life? Is that true?
Objection, relevance.
Mr. Edwards, the current U.S. Attorney has described your law firm as a criminal enterprise and part of the largest fraud in Florida's history. It has been reported that your firm fabricated multiple cases, many multiple cases against me in order to fleece unsuspecting investors out of millions and millions of dollars. Unfortunately, at this time, in response to your question, my attorneys advised me that I must assert my Sixth Amendment, Fifth Amendment, and 14th Amendment right. Though I believe you know that I would really like to answer your questions today, but at this moment I must assert those rights or risk having my attorneys resign.
You're invoking your Fifth Amendment right to each of these questions because you know that your answers will incriminate you and you feel that it will result in you being prosecuted for these crimes. Isn't that right?
Objection, argumentative, harassing, and calls for a legal conclusion.
Yeah.
No, in fact, the Supreme Court recently said that the Fifth Amendment right is there to protect the innocent. So that's the way I'd like to answer that.
Are you actually telling the jury that you didn't commit the crimes that have been alleged against you by the various females that were underage when you engaged in sex with them? Are you telling the jury that right now?
Objection, argumentative, harassing.
I would like to respond to that question, as you know. However, at the present time, my attorneys have counseled me that I cannot provide answers to any questions relevant to this lawsuit, and I must accept their advice or risk losing my Sixth Amendment right to effective representation. Accordingly, I assert my Fifth, Sixth, and 14th Amendment right under the United States Constitution.
Mr. Epstein, you understand that this is the video that will be played to the jury in trial against you, and wants answers. These juries are going to, the jury is going to want answers. So I know that you're telling us that you're going to respond at some time in the future, but the time is now. Would you like this opportunity to explain why you engaged in sexual activity with beginning when she was 13 years old and you were 50 years old?
I'm going to object once again. We're getting way too
questions definitively. Instead, it left an absence. And absence breeds doubt. The network question. One of the most persistent uncertainties surrounds the broader circle. The files show meetings. They show travel logs. They show overlapping social circles involving powerful individuals from politics, academia, finance, and entertainment. But proximity is not proof. That legal truth exists side by side with public suspicion. Were there others directly involved who were never charged? Were there individuals who suspected wrongdoing but stayed silent? Were there institutions that ignored warning signs? Investigations have not publicly named additional co-conspirators beyond those charged. That fact calms some observers and frustrates others. When a network appears large, but prosecutions appear limited, the disconnect invites scrutiny. Financial mysteries.
Police reports, financial records, a lot of it is exactly what you would expect. Disturbing, suggestive, grim, procedural, and it kind of lays out what this guy's life was like and who he was talking to. But in that mountain of paper, we have started to uncover threads that appear to deviate from the main story here. Threads that pointed beyond the criminal activity or the alleged criminal activity towards what he was building, who he was protecting, what he intended to leave behind. And that is where we get to Karina Shuliak, because she wasn't in the headlines about the victims or the trial. She wasn't Ghislaine Maxwell. Her name popped up in the financial documents, a trust, a will, the asset lists, the stuff that deals not with the past, but with the future, what Epstein planned. And one of the biggest funds that we have uncovered is a document called the 1953 Trust. It was dated August 8th, 2019. Now, Epstein signed it while he was in jail, right? This is as he was awaiting trial on federal sex crimes charges, sex trafficking. And then 2 days later, after he signed it, he's dead. And the document was basically his blueprint for what happened to his empire, valued at over $600 million at the time after he was gone. And by the way, we knew about this document. It was referenced in his will, which was publicized. It was mentioned in litigation over the years, but we really didn't know the exact content of it and what it shows us. It was kind of a secret. So this is big. And right there at the very top of the beneficiary list, Karina Shuliak, set to receive more money than anybody else, plus all of his iconic properties. And according to Business Insider, this document superseded an earlier trust from just January of that year, which had named apparently someone else at the top of the beneficiary list. So that document, which they say was called the Jeffrey E. Epstein 2019 Trust, it's actually no longer available on the DOJ site, by the way. We actually tried to find it, we couldn't. But Business Insider says they saw it, and so that would mean between January and August, something changed dramatically. Now that is the document trail that led us to her, and it raised immediate questions. Who was this person who suddenly became the centerpiece of his final plans? What was their relationship? What does her prominence to these files tell us about Epstein's inner world that we don't fully understand? What did she know? So we're going to get to all of that with our guests, but first, let me just quickly run through what we seem to know about Shuliak from the public record. So the basic facts before we dive into the documents themselves. What do we know about her? Well, if you were to sketch a profile from the public reporting from outlets like the New York Times, Business Insider, The Independent, here's the picture that comes together. She's a Belarusian immigrant. She came to the United States in 2009 when she was about 20. She entered Epstein's life not long after, which is interesting, right? Because that was right after he was convicted in Florida for sex crimes. And this is, again, when a lot of his old social circle had peeled away. In fact, a source quoted by the Daily Mail claimed that her willingness to stand by him after his initial disgrace, that only strengthened their relationship. Now, she was trained as a dentist. The Independent reports Epstein actually helped pay her way through dental school at Columbia University. She was licensed in Florida and California. She was even linked to a dental office in St. Thomas that shared an address with one of Epstein's shell companies, which is interesting, by the way, because in a previous episode of Sidebar, remember we showed you an image of a dentist chair that was found in a room on Epstein's island? We couldn't really confirm what that was, but it does make you think, does this have anything to do with Shuliak if she's a dentist? I mean, you gotta wonder if there was some sort of correlation there considering her profession. But here's the thing, for much of their alleged decade-long relationship, and I don't know if it was on again, off again, or what the circumstances were, Shuliak was actually married to another woman in Epstein's world. I'm talking about Jennifer Callan. Their wedding was in 2013, and lawyers for Epstein's victims have alleged that his network used sham same-sex marriages to help associates with immigration status and citizenship to keep it all under the radar. And Shuliak and Callan, they divorced in 2019. Remember, this was right about the time of Epstein's arrest. Personality-wise, the description...
Money often tells the story. How was wealth structured? Where did funding originate? How were payments disguised? Were there undisclosed beneficiaries? Financial records have been examined, assets were seized, civil settlements were reached, yet the complete financial ecosystem that supported the operation remains complex. Still, every withheld identity becomes a source of curiosity. Another dimension of what may be missing lies in voices unheard. Not every survivor testifies publicly. Trauma is personal, fear is real, privacy matters. There may be accounts that remain undisclosed, not because of concealment by authorities, but because individuals chose not to relive their experiences in court. That silence does not imply absence of truth, it may reflect survival. High-profile cases involving wealth and influence often leave behind a tension between documented fact and lingering doubt. On one side, convictions, transcripts, court findings, official investigations. On the other, unanswered questions.
That's the who. But to really understand the why, like why her, why then, what it meant, we got to go to the documents themselves, and that is where the story moves from biography into something else, something a lot more complex. And to do this, I want to break it down, but I want to bring on a special guest, okay? Somebody who has been tracking all of the Epstein files that have been released. Justin Shepard, host of the Just in the Nick of Crime show, the podcast. It's amazing. Justin, thank you so much for taking the time. Before I even get into this specific issue, I mean, I have been following your account for the last 5 days. You have been very specific in what you've noted from the document release. Generally speaking, what do you think some of the biggest takeaways are from this Epstein file release in the last few days?
Well, I think that it's not even that I'm trying to be pointed with it. There is just so much information coming out. There are names that, we didn't know before. You're hearing about this secret baby clinic that he wanted to do. You're now hearing, things about Bill Gates, and you're hearing things about Donald Trump, and you're hearing things about Matt Groening, the creator of The Simpsons. Jerry Seinfeld, like massive names that are now being brought up and brought into this, things about Vladimir Putin. So it's really all over the place. One thing that's kind of a takeaway for me, it's really insane how massive this network was, how many very well-known people are in this network, are being named or somehow in this sphere of influence, if you will. Obviously, just being in that sphere does not equate to committing a crime. But just being in that, the amount of access that Jeffrey Epstein had to these people, and nobody really knew about it until this whole document dump started coming out. It's almost mind-boggling.
And again, let me just put the caveat. Somebody might know Epstein, somebody might have been in his orbit per se, doesn't mean that they were involved in criminal activity
Correct.
or had knowledge of criminal activity, but obviously, being mentioned with him is so toxic. And the interesting part about this too, what's happening, and before we get into Corinna Shuliak, the Clintons, right? The Clintons have now agreed to testify on Capitol Hill about Jeffrey Epstein. I was listening to Cuomo last night on News Nation, and he had on Vicky Ward, and he asked her, what would you want the Clintons to be asked? And she was basically, I want to know, like, what were they expecting from Epstein? Like, what did they think they were going to get? What do you think about the Clintons and what they might testify to regarding him?
So the Clintons are an interesting group of people. Bill Clinton, going back to even his time in office, even his time as governor of Arkansas, there have been rumors surrounding him with impropriety with young girls, et cetera. I'm not saying anything illegal, but just those rumors and speculation have been there for decades. At the same time, when you look at kind of everything that's gone on with Congress and the potential contempt, because I believe that they were going to vote for a contempt hearing later this week, I think possibly tomorrow, when they decided all of a sudden, okay, well, we'll go ahead and testify. I don't know what they're planning on doing, but here's what I do know. Both of them are incredible. Bill and Hillary Clinton are incredibly intelligent individuals. Both have law degrees. He's a Rhodes Scholar. She came from Yale. So whatever they're planning on doing, in my opinion, there was a method to their madness in delaying their testifying, and I'm very interested to kind of see what comes out of this.
I think we all are. So we'll see what happens there. But now I want to go on to the main focus of this episode. Corinna Shuliak, okay? Is this somebody that you knew before? Is this somebody, her name surfacing so prominently in these financial...
Sealed documents, the trial that never occurred. The truth likely lies somewhere within that space. It is possible that most legally actionable evidence has already been pursued. It is possible that additional wrongdoing, if it existed, was insufficient to prosecute. It is possible that what remains sealed protects victims, not perpetrators. But it is also true that public trust erodes when transparency feels incomplete. The psychological weight of unfinished. Perhaps what's still missing is not a single explosive revelation, but a sense of closure. The scandal exposed systemic failures, early plea deals criticized as lenient, institutional blind spots, environments where influence muted oversight. When systems fail, the public expects a sweeping reckoning. Instead, the outcome has been narrower: one major conviction for facilitation, civil settlements, reputational fallout. For some, that feels proportionate to evidence. For others, it feels insufficient compared to the scale of the network. That emotional imbalance sustains the question, what's still missing? The enduring echo. Years after the headlines first exploded, the files continue to resurface, the testimony continues to be dissected, the redactions continue to be debated. The absence of total transparency becomes part of the narrative itself. Yet one fact remains steady: accountability did occur, even if not to the extent some anticipated. A conviction was secured, survivors were heard in court, institutions faced scrutiny. Still, the shadow lingers. Not because every secret is necessarily buried, but because in cases where power and exploitation intersect, the expectation of full illumination is enormous. And when even a sliver of darkness remains, the imagination fills it. What's still missing? Perhaps definitive closure, perhaps absolute transparency, or perhaps simply the reassurance that nothing more was left untouched. Until that reassurance feels complete, the question will continue to echo, quietly, persistently, between the pages of the files and the lines of testimony that reshaped a global conversation.